looks like we have most of our registrants here in the session. So we can go ahead and get started. Hi, everyone. Welcome in to another CourseKey webinar. My name is Alex Weitzel. I'm the marketing manager at CourseKey. And today we're going to be talking about compliance and specifically some of the new regulations, proposed regulations coming out of the Department of Education and how you and your school can prepare for those. I'm really excited because I'm by no means an expert on this subject, and that's why I'm thrilled that we have Jacob Bonifield here with us today. He is of counsel at Dentons in Washington, D.C., which is the largest law firm in the world. So Jacob, thanks for being here and welcome in.
Thanks, Alex. And thanks to everyone who's joined us this afternoon. An exciting day in higher education. It isn't often that my phone between CNN, Politico, The Hill, and the New York Times is ringing with higher education headlines. But as most of you have inevitably seen this morning, the president and the U.S. Department of Education put out policy statements indicating their intention to forgive $10,000 and $20,000 respectively for two categories of borrowers across the board. And this has been driven after months and months of delay by what is essentially a political impetus for action. We're sitting here at close to $2 trillion in student debt outstanding. It's taken up space on kitchen tables in DC around policy roundtables, speeches in Congress, and certainly the US Department of Education. What a lot of people don't realize, though, is that even as significant as today's announcement is in the larger student debt debate, what we're about to talk about, as dry as it may sound in its headline, is significantly more important in my view, and will have a much larger impact, not just on student debt in the United States, but also on the viability of institutions, because ultimately it's colleges and universities that are going to pick up the tab. So we're going to get into all that in a second. Let me give a high-level quick overview of what I do. I'm a higher education lawyer and lobbyist. I'm a substantive lawyer first. I represent institutions in all sorts of capacities before regulatory tribunals, before Congress, the U.S. Department of Education, state legislatures in some circumstances. And then I also deal with the day-to-day higher education lawyering needs that arise, in between and among those relationships. My focus and background has been as something between a political lawyer and a regulatory lawyer, and borrower defense is one of the best examples of where those two worlds have collided in unbelievable fashion. So as we've seen Congress and the department frustrated in their efforts to provide large-scale loan relief, we've seen the pressure build up on President Biden to take action. He's finally done that today after 2 years of delay. And it is by no means the end of the story. So I'm looking forward to getting into borrower defense and what that means for your institutions and what it portends for the larger higher ed policy realm. But let me just say at the outset that I am not at all thrown off by the interjection of questions or comments, thoughts throughout it. I think the more interactive, the more beneficial to this audience across the board. So please don't hesitate to throw questions and comments in the chat as we move along. And then Alex, if you want to move us a slide along here, we can get in overview.
I have a quick intro that,
please
you got me fired up and I want to hear about all this. So I'm just going to breeze through the intro and then we can turn it over to you. A lot of things that I'm excited to hear about, as I'm sure our attendees are. So real quick, for those of you who aren't familiar with CourseKey, we're a vocational intelligence platform, and we work with over 300 plus campuses across the country. What does that mean? We build solutions, specifically software solutions, specifically for vocational education institutions. And this suite of solutions spans the entire student life cycle. So all the way from enrolling the student and enrollment, all the way to placing them and getting them started in their career. Last thing is we are currently investing about $25 million into helping schools just like yours train the next generation of essential workers. So that's a brief overview of CourseKey. There's a lot more to us. You can go learn more at CourseKey.com. We have a ton of resources there that you can read about and get familiar with who we are. But today we are here to hear from Jake. Two other quick things. Like Jake mentioned, we do encourage you to ask questions, and if we don't get to answer all the questions you have, I will be marking down who asked what, and we'll follow up with you via email. And then the second thing is that this is a recorded webinar, so all the registrants and including all the attendees here today, you'll get a copy of this webinar either in your inbox tonight or at the very latest tomorrow. So, okay, thanks for bearing with me. These outcomes are pretty much exactly what Jake said. Is he's going to give you an overview of these pending regulations, understand what you and your institution should be thinking about, and how to prepare for 2023 with some general compliance tips as well. And then I'm going to just give a brief summary of how CourseKey is helping institutions with their compliance using our software solutions. Okay, so now Jake, the floor is yours, man of the hour. Take it away.
Yeah, thanks very much, Alex. We're going to start with, as you all are probably well aware, the Department of Education has been as busy as I've ever seen it since the inception of the Biden administration in addressing each of the topics listed here and many more. Borrower defense to repayment is going to have the most sizable, in my view, an estimation, the most sizable financial and operational impact of any rule I've ever seen promulgated by the Department of Education. The net effect of borrower defense, if it's realized in the current form I'm about to describe to all of you, would be to take a substantial step toward turning the U.S. Federal Student Loan Program closer to a federal student grant program, candidly. They have opened up the doors so wide that just about anybody can walk through with a plausible claim of misrepresentation, misleading use of statistics, of frankly a less than ideal interaction or experience with a frontline employee of an institution, or find a technical misidentification or mistake in any number of materials, marketing, admissions, or otherwise, and could plausibly state a claim for full student loan relief based on the standards that are being put forth in this draft rule. I mention that because we're going to give short shrift to the gainful employment rule, to 9010 and administrative capabilities, to the closed school discharges, and some of the other regs that are trickling out, because I think the impact of BDR is so great. But I will make a comment quickly for those of you interested in gainful employment. It's now our expectation, based on the department's posture, that this rule, because they've missed their deadline per the master calendar, will not see this rule until next year, likely around April, springtime or so, which means it will not have an effective date, what they eventually promulgate, until the middle of 2024. So that neuters what was a prime policy objective for Undersecretary Cabal and the administration, but it will still come. We have every expectation it will come down the pike next spring and come to fruition. But I just make that note for the folks on this call who are at proprietary institutions or who are otherwise interested in the rule. So from there, let's move briskly on to borrower defense itself. So borrower defense to repayment, 30 seconds of background, was a concept first introduced in the Higher Education Act when it was reauthorized in 1994. It was a very simple concept. It said that the U.S. Department of Education could entertain from a borrower upon whom they were trying to collect a student debt, a student loan repayment, they could entertain a defense to repayment, whereby if the student or the borrower, one and the same, had been misled or suffered a substantial misrepresentation or a couple other categories, including closed school discharge, and were subject to those requirements. If they met those criteria, the U.S. Department of Education could promulgate a rule whereby they would set standards for forgiving the loan. And that simple language, which was in statute since 1994, was codified and regulated through regulations promulgated initially in 1995. It's set largely dormant. As best we can tell, there were between 10 and 30 actual claims of borrower defense to repayment between 1994 and 2016. In 2016, the Obama administration, in its waning days, decided to use this rule to greatly expand relief for student borrowers in the wake of ITT and Corinthians abrupt closures. And so there were sort of two tracks. They set up closed school discharge tracks for those who had attended the institutions, and they could seek relief on the grounds that the institution closed and they weren't allowed to get the full benefit of their education. But they also set a second track that took advantage of the statute in providing for wide-ranging relief for students who felt they'd been misled. It was that rule that, while instituted under the Obama administration, was largely neutered under the subsequent DeVos, President Trump, but Secretary DeVos in particular at the U.S. Department of Education didn't like it. They felt it was too liberal. So there was a series of court wrangling, back and forth, lawsuits, some of which are still pending over the viability of the much condensed rule that the DeVos administration put forward. I won't bore you with all the technical back and forth, except to say that the borrower defense to repayment rule right now is about to be revived to everything it was in the Obama administration and then some. And there are, depending on how you look at it, about 6 categories, 6 triggers, if you will, that a student borrower can assert and prove, though we'll get to why I say that with some trepidation in a moment. But if they assert that they've suffered a substantial misrepresentation, a substantial omission of fact, in other words, the school, employee, third-party lead generator, anybody in privity with the school failed to provide all of the material facts relevant to the students making the decision whether to enroll. If any of these separate triggers are found to be true, this now triggers full presumption of full loan relief. So if your catalog was out of date, it listed instructors with different credentials than they have now. It listed courses you no longer offer, any number of potential misleading, if not outright deceptive omissions or positive statements can trigger the possibility of full loan relief. That loan relief is then put on the institution, and the Department of Education will do its best to recover those funds straight from schools. So among the list here, substantial misrepresentation, substantial omissions of fact, a breach of contract, that would be, for instance, an enrollment agreement, though the department's been a little cagey as to what contracts are in play. Any adverse adjudications, adverse final judgments reached by a court or a tribunal. Importantly here, you'll note that I wrote in there "and ED actions included." This means, and this is a huge deal, this is new under this rule, that prior program reviews, prior departmental findings against and about an institution can trigger borrower defense claims. And you may think to yourself, well, what's the likelihood a student who may feel aggrieved knows about our program review findings, or that the department took issue with what were fundamentally internal documents, right? Internal statistics that never made it onto a marketing material or course catalog. What are the odds that triggers a claim? ED has now reserved to itself the right to create group claims based upon previous departmental actions. And there is no statute of limitations in terms of how far the department can go back. And so this is a tremendously concerning development. You can imagine, those of you who've been in the rooms for program reviews and other departmental proceedings, they find all sorts of stuff, right? I mean, it's a very intense audit process. This now opens that liability up far beyond what you might have owed to the department as a penalty for breaking internal policies and procedures, or making a mistake in good faith, or what have you, any number of things they could find in a program review. This now expands that liability to potentially encompass students with their loans who attended during the period that was audited. And so all of this is just it was sort of mind-boggling expansions of liabilities, but none really trumps the aggressive and deceptive recruitment category, which is a new category being added to the borrower defense regimen. It's aimed at for-profits, but let me just take a moment and get on my lawyer's soapbox here to emphasize to this crowd And I hope you'll tell all of your colleagues in higher education, you sit next on the, on the bus next to a nonprofit or public president or trustee or whomever, to emphasize to them that everything we're talking about here today applies equally to nonprofit, public, and for-profit institutions. Full stop. So in the wake of the president's announcement today on student loan forgiveness, as a political guy and somebody with a lot of friends in higher education, I've been fielding any number of texts. And I'll tell you that one of them came from a friend of mine who is pretty liberal, sort of a Bernie Sanders supporter type, who's also happens to be a lawyer who went to an Ivy League law school. And his comment to me was he felt that the actions taken today by President Biden were insufficient and were a drop in the bucket. And he indicated to me that the borrower defense rule, as it's being pushed out, may well be a better basis for him to seek to mitigate and relieve some of his $500,000 in student loans. This is somebody making a good income, well-educated, a lawyer. I mean, the enticement here for student loan borrowers is difficult to overstate. And again, institutions like yours are going to pick up the tab. So in my view, this is the topic of the hour. So let's get to it. Again, this creates new frontiers of potential claims. There is a presumption of full relief of everything, every dollar they took out of an institution, regardless of whether or not the misrepresentation or omission or aggressive and deceptive recruitment happened in the first semester and they attended another 4-6 years after that. The presumption is in favor of full relief. And I have every expectation that is how the department will go about reviewing and approving claims, is with a presumption of full relief. They also presume reliance. So you can imagine a dusty enrollment agreement, a catalog, a marketing material is sitting on the table. An admissions representative says to the student accurately that they no longer offer medical assisting program, let's say. The student attends, gets their CNA or they get their nursing degree or what have you, but later alleges that the catalog that had been sitting on that table hadn't been updated. It said that they still offered the program in question. The Department of Education says explicitly in this draft rule that they are going to take the word of the student alleging that over any written material that may be provided. In other words, it works both ways. If an admissions representative says something that's accurate, but you have a printed material that says something that's inaccurate, it is more likely than not that the student is going to be able to point to that printed material and say, I was misled. It works the other way as well, and the department is going to preference a student's recollection of their interaction. They actually say in here, a borrower can achieve these goals we're talking about by relaying with some detail the story of their recruitment experience or other interaction with the school, and they are going to preference that over the written material that a school may be able to provide. So let me just read to you for a moment to emphasize this point. In responding to this is straight from the rule, in responding to the allegations in borrower defense claims, some institutions have asserted that written statements, even if buried in material provided to the students, are sufficient to correct inaccurate information from recruiters. The department disagrees with this view. As a practical matter, the recruiter is providing personal support to the borrower. They're often their first interaction and gateway, on and on and on. I mean, the department makes it clear that having sort of these disclaimers and warranties and accurate information in written materials is no guard against allegations that your representative, your employee misled a student. This is going to create a huge range of issues. But let's move on to the next slide here for a moment, and I can lend a little bit more insight into the aggressive recruitment facets that are of particular concern, I think. So the department has, out of whole cloth, effectively created a new category of borrower defense claims beyond omission of fact, beyond substantial misrepresentation. And this is they're calling aggressive and deceptive recruitment, or aggressive recruitment is the shortened title. This means, in the department's estimation, that the school, has exerted unreasonable pressure upon a consumer to enroll in an institution. including, as an example, by exploiting a consumer's fears, anxieties, insecurities, or any specific misfortune or circumstance of such gravity as to impair the consumer's judgment, to influence the consumer's decision with regard to the institution. Now, it's important to note at this juncture that there is no intent standard here. In other words, when they write exploiting a consumer's fears, anxieties, insecurities, you don't have to have done it intentionally. In fact, they don't care whether the misrepresentation, the aggressive recruitment, or the omission of fact happened intentionally. So without a full psychological profile of a prospective student, without understanding their family history, whether a lack of background in higher education, socioeconomics, as you'll read the second and third bullet points here, or otherwise that it was unreasonable how you interacted with a student, without knowing any of that, you could be subjecting the institution to forgiveness of and ultimately subsidy of the entirety of the loans that student takes out. So needless to say, this has triggered among, I think, smart actors who are paying attention to the scale of borrower defense. They've been clamoring for, my inbox is full right now, of presidents and compliance directors asking for what we're calling borrower defense audits. In other words, there's no way to warrant against all of this liability that's going to come down the pike, but you can put yourself in a better position if you take a thorough look at, ideally with assistance of counsel, but regardless, a thorough look at your marketing, forward-facing materials. The department specifically calls out lead generators. They call out third-party websites that they view as occasionally being deceptive. All of these outward reaches, if you will, from an institution to a prospective student, whether passive or otherwise, are potential tentacles to bringing in large amounts of liability. And I don't have to tell this crowd how much money we're talking about here. I mean, I don't know the last time your compliance office made a mistake that came with an 8-figure bill, but I have a client right now who just received the bill effectively for the first tranche of approved borrower defense claims put against it under the previous regiments, which were more restrictive, more conservative, and harder to meet the standards. And they currently have an 8-figure liability owed to the department, tens of millions of dollars, and it is the tip of the iceberg. So this is going to be a problem. It's going to be a problem for graduate schools, for elite nonprofits, for anybody who's expensive, candidly. It's going to be a problem for master's degree programs, for graduate schools of all kinds. I've been raising the alarm with law schools in particular, given the cost and the employment outcomes for many of their graduates. There's going to be an intense incentive for graduate borrowers to come back and allege any number of these relatively easy to assert and meet thresholds in seeking full loan forgiveness. And there's no requirement they prove reliance, as you would at common law for fraudulent misrepresentation. There's a rebuttable presumption of full relief, which under this department will almost certainly guarantee full relief for a wide swath, if not majority, of applicants whose applications are granted. And it also means that institutions are going to be footed with the bill. So difficult to overstate. Let's move on to the next slide, and I will try to give a few other thoughts here on mitigation. So this is a classic example. Given every constraints on time, as a compliance officer, as in-house counsel, as anybody involved and charged with compliance, given the regulatory scheme, the requirements at the state level, at the federal level, we're all inundated. This is a classic example, though, of where I think you need to be proactive, because the second one of these liabilities hits the desks, particularly at the C-suite level, my experience has been that owners, executives, and trustees of institutions, again, of all stripes, are hyper focused on liabilities of this sort, even as many folks sort of a few tranches down from them are more concerned with, getting your accreditation paperwork in and the standard day-to-day requirements of everything from SAP to Title IX and the like. And those things are obviously important, but this represents what I think could be a cataclysmic liability for almost any institution. So what can you do? You can engage legal counsel to examine risk points based on previous actions. One of the things we've started doing here at Dentons has been compiling everything that's public right now about borrower defense claims and trying to put together guides for individual institutions based upon their programmatic mix, their student mix, how their admissions apparatus works, and putting together best practices for individual institutions to try to mitigate the risk of and potential damage from borrower defense claims. I think you've got to do a risk assessment that's soup to nuts, everything marketing, admissions, anything student facing or potentially student facing could grab you. Previous audit and program review materials need to be reviewed in a new light, given the risk that future audits and program reviews can trigger borrower defense claims. And you need a plan for risk mitigation. Most of the folks on this call, if you were sort of alert enough to attend something like this, I'm sure you've got internal compliance protocols. I think now is the time to re-examine those in view of the liabilities we're seeing cascade down from the borrower defense rule in particular. We can help with that, obviously. A thorough scrub of everything and heightened training materials and protocols are the tip of the iceberg. And then there's about 1,000 other things I could recommend, but those are sort of the highlights. And if anybody wants to talk offline, I think I'll have my contact info or something at the end of the presentation. But let me just crystallize for a moment what I think is going to happen next. The department has made it clear that this liberalized rule, which again presumes 2/3 of what you normally have to prove in court to successfully move on or successfully win a misrepresentation lawsuit, the claims are going to come from everywhere. And to the degree that individuals aren't savvy enough or made aware by, among others, the plaintiff's bar, that this is an option for them, the rule contemplates a group process that can be initiated by the U.S. Department of Education. State attorneys general can initiate group process claims. So if you've got a pet school that you're not particularly fond of in your state, you can find some less than you can find some examples, I suppose, less than complimentary examples of behavior of marketing of forward-facing statements that institution made. You can round up groups of students and you can send them over to the Department of Education, and they will all but take care of what would otherwise be a massive class action undertaking through this process. At the end of the day, the school is very likely to get the bill for those loans which are forgiven through that process. So it represents a massive risk. And I think that we can't do enough to raise the alarm bells among schools across the board from all sectors about what this portends in terms of liability. Alex, do we have any questions or anything that's come through?
We don't have any questions that have come through. I'll just say that this is really serious stuff, and thanks for taking us through kind of the overview of it. I was definitely not aware of how important this all was and how critical it is. And I hope that our attendees here in our schools have been able to really understand the full breadth of what's going on and how important it is to protect your institution. We do have one person who just raised their hand. Let's see if I can let him speak. Ryan, I see it was you. Let me see. Where is your contact here? Sorry, one second. There it is. All right, Ryan, you're able to talk.
Yeah, actually, I've been having quite a few conversations with potential partners. I work more on the sales side, and one of the things that I've heard a lot is a lot of the owners are kind of asking, how do they improve the student experience, just because they feel like word of mouth and big reputation is probably one of the better ways to offset, I guess, some of the things that they're saying you can't do as a business practice. Are there certain things that when you say take a look at student facing things, what are you talking about specifically, and what should schools be evaluating when it comes to those parts of their student life cycle?
Yeah, absolutely. So let me give you some examples straight from the department. There are what have traditionally been pain points from a compliance standpoint. And really what I mean by that is anything that comes down to a concrete number that might change or might be difficult to justify or to back up, if you will, in the context of a departmental inquiry. Job placement rate is sort of exhibit A. Our job placement rate is 80%. 75% of whom are employed in field. Well, there are no federal standards that either the department recognizes or have been codified at any level that's relevant to this sort of a thing that tell you how you should calculate a job placement rate, much less what constitutes in field for any number of regulars. So right there's sort of a huge marker of potential. The other is what would otherwise seem innocuous language, Ryan, things like self-paced programming and average time to completion, or you could complete self-paced program X in 18 months. Well, in many cases, that's true, but it's not the norm. What the department has said is that putting those two things together could amount to a deceptive or aggressive recruiting tactic or an omission of fact. So if you name something that could be forward-facing, I can give you an example of how that could be sort of weaponized against the school, but I could also equally give you strategies and thoughts and ideas based on what we're seeing to mitigate that risk, not eliminate it, but to soften, mitigate, and qualify those sorts of claims.
And have you found that there's, I guess, more of a challenge for schools that are still very maybe manual in their processes? Because a lot of the folks that we talk with are, our big conversation is about what does it look like, and what is the experience of data collection, who's involved, and how are you getting into the systems that are producing your LDA and SAP reports and things like that. Have you found the schools with maybe more, I guess, lack of a better term, archaic systems are more prone for that kind of stuff, just in terms of being able to prove where their data comes from and the records behind it?
You would think that's a very logical thing that you would expect me to say yes to. The breadth and nature of this rule and the selective enforcement by the Department of Education is such that the client I referenced earlier with an 8-figure liability is a name you would recognize and is one of the most sophisticated, well-run, good, in my opinion, great actor institutions that you'll find. What they did in that instance, the department went back to the 70s and asked for documentation. So look, the net of this is, yes, automate processes, make sure you're auditing your processes thoroughly. But it's very difficult to give a generalized statement as to what's best or what's not, because the nature of the threat keeps changing. And that's where I think it's a more sophisticated and nuanced conversation as to what needs to happen than these bullets. But it's a great question, and I know that's a little off script, that answer, but that's truly what we're seeing, is that sophisticated players are getting nailed. So folks who aren't paying attention to this, you can only imagine the liability that's out there.
Absolutely. Thank you. Appreciate that.
Yeah, thanks, Ryan. I appreciate the question.
Yeah, thanks, Ryan. And I saw a few questions come in about the recording being available later. Yes, this recording will be sent to those who've registered, and of course, all of you who are in attendance today. It'll either come later today or by at the latest by tomorrow. So you will be able to review this, because I know there's a lot of great information here. Last call for any questions. We have a few more minutes here. Jake, this has been really informative, and just thanks, even though we're not at the end, but thank you.
No, I appreciate it. And if you want to move forward, just, I know in case people need to wrap up, but I think I've got do I have my contact info on the last slide or something like that? And I can keep talking and answering questions in the meantime. But just so folks feel free to shoot me an email, give me a call. I'm very happy to talk, casually and offline with you all, or any other stakeholders. You mentioned owner or president. I mean, I have found that sophisticated investors, owners, leaders of schools, if this is not on their radar, you're going to pick up a lot of yardage by bringing it to them, because it, again, is nothing short of a potential death knell for institutions. Let me give a couple other quick hit examples of where this liability can be found. when we talk about substantial misrepresentations and we say that a student doesn't have to prove reliance, they don't have to prove damages, we're talking about almost anything in the department's estimation above, the promise of $150, course packet that was never received. The department has taken pains to give us a few morsels of give back and say, at a level of $150, that's too nominal an injury. That's too, but you can imagine how anything above that, right? Anything to do with course offerings, price, outcomes of any kind, things that can change much more frequently than admissions materials, course catalogs, and websites are updated. Any gap in those disclaimers versus the sort of realities on the ground creates the liability for a borrower defense to repayment discharge. And I will tell you that the department has made it so easy a standard to meet for a borrower that if a borrower is denied or a group of borrowers are denied or a state attorney general that's created a class of potential borrowers seeking relief is shot down, they've allowed for those groups, the individual, the group, and the group initiated by someone like a state attorney general to seek reconsideration. So you get a second bite at the apple. They have not allowed institutions to seek reconsideration of an application that's granted against them. And I cannot emphasize enough, not only how important mitigation strategies are, but you have got to be prepared to respond to these claims in a timely fashion when they reach the department, because failure to respond within the short time frame they give institutions will result in the department essentially taking your non-response to be an acquiescence, right? So a lack of denial, a lack of contest results in the department determining that the school must agree with the students' allegations that they were misled and are in line for relief. And that zaps just about all of your options for contesting on the recoupment side. Because the other thing I didn't probably lay out well enough early is that this is all happening in a vacuum at the Department of Education. It's not a judge. It's not even an administrative law judge. It is any official, a department official that's designated for this task is who will be reviewing these claims. So you've put your potential future of your institution from a financial liability standpoint in the hands of what could be a random official at the Department of Education in service of a larger political agenda we're seeing play out right now in the headlines with institutions set to pick up the tab. I mean, it's really, I've become one of those raving, academics or lawyers who, focuses on a little niche and then, oh my God, the whole world is ending. But it's difficult to overstate how easy it will be for students to get relief. And it's difficult to overstate how many institutions I think are at risk now. Institutions, many of whom for-profit and otherwise, are having trouble, making ends meet in the current status quo, to say nothing of being presented with a surprise bill for potentially hundreds of thousands, if not millions of dollars in liabilities. So give me a call. Anybody who wants to talk or walk through this in greater detail. Is 750 pages long. I've just scratched the surface, but I hope I've done some justice to what I think the emerging threat is with respect to this rule, and very happy to continue the conversation with anyone interested.
Thanks, Jake, and I appreciate you offering our attendees that option to continue that conversation. If I could transition over to the course key side of this, I think what makes this particularly scary is the retroactive look back to what's happened in the past. I know that there's not much you can do right now to change, anything you can do to change the processes that you had back then. But moving forward, there are some things that vocational education institutions like you all can do. And that's, if I can look at it from a course key lens, the software that we offer really helps provide the transparency and the verification and the detailed accuracy for all of these tactics, not tactics, the processes that happen when a student is in class. And that ranges from attendance to tracking skills to evaluations and assessments, and also to generating reports. And I think the beauty of the software is that that data is first generated in real time and is uploaded to your institution systems without any human intervention and within a split second, thanks to integration, which allows your departments and your teams to act on that information rather than spend the time collecting it and organizing it. So that's just one way that software is will help streamline a lot of those processes and help you stay in front of some of the compliance issues that were mentioned, especially, I mean, borrower defense. If a student is going to claim that they didn't receive the education that they have been paying for, but they have records of their own student-driven attendance records in your system that you can point to. We've had partner institutions and customers tell us that they've been able to shoot down some claims really easily by just providing those simple records that were student-driven. So we'd love to talk to you more about how we can help with your compliance. Definitely, I would take advantage of Jake's offer to speak more about this. Clearly, it's very critical and very timely. So just so you all know, when you leave the session, we did have some questions. When you leave the session, there will be a survey that asks you if you'd like to speak with us about how we can help your institution. So just know that will pop up. There were, Jake, some more questions here. Let's see. Terry, yes, recording will be available. Nicholas said, thank you. Thanks, Nicholas, for being here. And then Ryan, one more question from him. He says, can this also help with externships and clinicals where the error rates on LDA tend to be higher? Jake, do you have any information there?
Yeah, so I assume he's asking about course key, right? He's asking about the offering, though I will mention just quickly the availability of externships, something called out by the department as a potential trigger for borrower defense claims. But go ahead, Alex. I'll let you talk to course key on that.
Thank you. Yes, so for externships and really any offsite hours that students are accruing, the same attendance process does apply. So we have different verification technology for student hours that really help with offsite. That includes geofencing, QR codes, voice recognition, but some multi-layered attendance verification methods that allow you and your students to get that attendance and those hours offsite into your SIS right away, which is extremely significantly faster than how we've seen schools traditionally handle that process. So yes, it definitely helps there. And that's one of the areas that we've actually seen that we set schools apart from their peer organizations.
That's well taken. Let me offer just real quickly, Alex, one final, and I should have worked this in earlier, but sometimes just reading the department's own language is a good encapsulation of what we're talking about here and how dangerous and expansive it is. This is straight from the rule. The department has seen institutions engage in behavior where the borrower is coerced into enrolling in a manner so aggressive that even if the information presented to them was accurate and without omissions, the borrower is not able to make a full and informed choice. 3 years of law school, 5 years plus of higher education specific practice. I was in-house at an institution before this. I can't tell you what that means in a practical sense, other than to tell you that they are aiming to make this as broad as possible. So I think you do well to put some time into preparing. And again, to the degree that I can be helpful, course key, any of us here, very happy to engage with you offline on that. But thank you so much to everyone for taking the time, and Alex for helping moderate and put this together. Certainly enjoyed being with you all.
Hey, you're welcome. And thank you for your time and for sharing your expertise. And thanks everyone for spending part of your day with us. We hope this was informative and valuable, and we hope to hear from you in the future. So have a great rest of your day, and we'll talk soon. Bye.